there's a school of thought that although in the sort of vernacular sense, Mr. Hillegas has sort of delusional beliefs, sort of these fundamentalist, bizarre, sovereign citizen beliefs.
All rise. The Second Judicial District Court of the State of Nevada is now in session. Honorable Barry Breslow presiding.
Thank you, Deputy. Good morning, everyone. Please be seated. All right, welcome to Department 8. This is the date and time set for a motion to confirm trial and final pretrial conference in the case of State of Nevada versus Stewart Handte. The court acknowledges Mr. Hante's present. Good morning, Mr. Handte.
Good morning, sir.
And the prosecutor, Mr. Stege. Good morning, Mr. Stege.
Good morning.
All right. Here's what's on the court's agenda. Hopefully it's on yours as well. And then we'll talk about anything I'm missing. The court recently denied the motion to dismiss, so that now has been resolved. There's a motion by Mr. Handte to proceed in form of pauperous. We'll talk about that. Mr. Handte filed recently a motion to disqualify the court. That stayed proceedings. And then Judge Riggs recently denied that unstated and resulted in the court's order late last week canceling last week's final pretrial conference and motion to confirm and moving it to today. We have a motion to change venue filed by Mr. Handte, arguing that he can't get a fair trial here in Washoe County. We have a motion by the State of Nevada for the court to rule before trial that it be allowed to introduce some prior acts of Mr. Handte for a non-propensity purpose, to which Mr. Handte has objected. Also counter-filed a motion to strike evidence. The court will attempt to liberally construe that to see what it is that Mr. Handte is asking the court to do, but it's clear Mr. Handte objects to any attempt by the state to introduce other interactions with the court system that Mr. Handte has had in the past. I want to make sure that Mr. Handte continues to abide this court's order that he have no contact with Mr. Hillegas. As I recall, previously the court indicated that while Mr. Hillegas was on a pending warrant status, Mr. Handte was to have no contact with him. It came to the court's attention that Mr. Hillegas was recently picked up in another state on the warrant. As far as I know, he's not back in Nevada, so we can determine what effect that has on the trial and also the no contact order. The court will look again at whether it would be a good idea to appoint someone as standby counsel for Mr. Handte, including if the court is inclined to do that, including whether that should be Mr. Kozak and whether his calendar has freed up in federal court so that he would even be available 2 weeks from today if we go to trial to assist the court in that way. I'm remembering from our hearing we had in September, for which Mr. Bolenbaker was here representing the state in place of Mr. Stege, objecting to any change in the pretrial condition of Mr. Handte with respect to the ankle monitor. The court recalls explaining that if it had a sufficient backup plan to monitor Mr. Hante's whereabouts, as well as some medical proof that it's causing a medical condition such that it's recommended to be removed, the court would reconsider its position. We have a request from our Nevada judges to video and maybe live stream, I'm not sure, the trial. The prior orders of the court have not yet addressed that. We have a recently filed petition for writ of mandamus filed by Mr. Handte on or about October 13th. Styled First Amendment petition, don't really see First Amendment issues in there. I see a lot of other concerns, but not those. We can talk about that. Then I want to talk about how this trial will go in terms of what day it starts, when we pick the jury, how questioning will occur, when jury instructions will be submitted, when the panel of prospective juror questionnaires will be available and how they are to be used, whether the state intends to access any databases reflecting criminal justice history of any jurors, and whether, how then that information would get to Mr. Handte and what he could do with it. We also have a change, I mentioned a change of venue motion that was filed by Mr. Handte, to which the state has not responded.
Venue? Okay.
Yeah, venue, that's the last thing I just said. I may have skipped over it. I have a request by Mr. Handte to change venue. Arguing that he can't get a fair trial here.
And Judge, I resubmitted that after Mr. Stege's opposition to both.
Understood. And so it's pending. The court's ready to talk about that. So without yet going into any of the motions or anything the court just said, let me start with Mr. Stege. Did I hit all the things we need to address, or are there others?
I think that's the universe that we're in right now.
Okay, Mr. Handte, did I cover everything that needs to be covered? And then-
Actually, no, Judge, I have an order that I submitted to the Resource Center this morning, 8/24. It's not been file stamped as approval. I gave Mr. Stege a copy, and I'd like to give the court a copy of this order.
in order
It's a
from,
motion.
Motion for assistance of legal counsel administrative functions.
say that again a little more slowly,
Okay, sorry. Motion for assistance of legal counsel and administrative functions.
that you filed today.
That's correct, Judge.
And just, I'll let you file in a second, but tell me what you're seeking the court to order.
Basically, I'm seeking the court to provide me with legal assistance in the defense of my case, as well as an investigator to help me out with tracking down witnesses, getting any possible further information and investigation from those witnesses, and issuing subpoenas to the witnesses that I intend to call for my trial.
Okay, that has not been filed yet.
It has been filed,
Okay,
but
so-
it has not been approved. It takes a little bit of a process time to approve.
Okay, and would you please hand that to the court clerk, and then she'll hand it to me, and then I'll have a copy of what you got.
I just don't have the court stamp.
Okay, understood. Thank you. Well, we might as well cover that first, because that might direct the tempo of the other things. So give me just a moment. Let me do it. All right, the court has read the motion for assistance of legal counsel and administrative functions that Mr. Handte has provided to the court, indicated was filed this morning. Mr. Stege, have you had a chance to read it?
Yes.
Do you have a position on it you want to share with the court at this time?
Only that we've twice been to Ferretta hearings with the defendant where it was made clear to him that he will be responsible for knowing and complying with the rules. Sort of the weight of that decision was squarely before the defendant. I note there have been 3 attorneys representing Mr. Handte in the life of this case. Mr. Gilbert, Mr. Pitaro, Mr. Kozak, briefly. So my worry is for more delay. If the issue of subpoenas is compelling or important in the case, I mean, that's manageable, I think. I think it's manageable through sort of court resources, and depending on the scope and size of there's the state has a large number of subpoenas out and is willing to, as long as it's not excessive, sort of subpoena people on behalf of the defendant. But otherwise, it's not clear why, right? Or sort of I don't see a compelling sort of reason for it here. And I wouldn't want to be, what I don't want is where we've been a number of times, that this indecision on who's in charge of the legal defense.
Well, I'll hear from Mr. Handte in a minute, but let's suppose he says, Judge, I've changed my mind. I thought about it some more. I've read your orders, in particular your order denying the motion to dismiss that I put a lot of time and energy into. And I might realize now I'm a bit outgunned. And with trial standard down I would like the benefit of counsel. And let's assume that I put Mr. Handte under oath and I canvass him, and financially he's not able to hire somebody to defend him. What then? What then is the state's position?
Well, in that instant, if the court sort of undoes the Ferretta, I no longer wish to represent myself. If this
Well,
was a,
I'll pause right there, because I'm trying to remember if at the last Ferretta, or either, I said, if you later change your mind, there's no guarantee I'm going to allow you to have new counsel and vacate the trial date to let him or her prepare, or that I appoint you a free lawyer if you cannot afford one. I said, know that, and that was part of the canvas, I recall, and I believe Mr. Handte said to the effect, with full knowledge of that, I'm prepared to represent myself.
right, I seem to recall that as well as the court's sort of interest or keeping its finger on the pulse of, standby counsel should that arise. But typically standby, the times I've seen it, which I admit have been rare, standby counsel tends to be more where it's clear a defendant is not following the rules or capable of following either basic rules of filing stuff and sort of procedural stuff as well as courtroom.
Well, that's not what we have here. We have
Which we
somebody
don't have here.
who believes, who may be now believing that, to use the phrase I mentioned a moment ago, might be outgunned.
Right. Although, if we take a step back, many of these motions, regardless of who's filing them, are not going to be granted, right? That's the typical life, speaking frankly, of a criminal case is defense motions filed, most of them not granted, and then proceeding to trial. That's sort of the general scope of things. It's not that, only the court can assess that, but whether he's outgunned in sort of the legal motions he's filing, I think, in any instance, there's not much substance.
Well, there's more than that, right? You mentioned the subpoenas and
Right.
evidence review and things like that. So it's not simply filing legal papers with legal
Right.
analysis and persuasive legal writing.
Right, and here I am offering some subpoena help in that regard, and I guess the question of an investigator, right, that's sort of unique in that I don't think it's directly part of the canvas, in the sense of this general, you're in for, you're doing a big thing here, and that's sort of included in there. I sort of would weigh that with this, right? In certain instances, the court has the authority to appoint, spend public money for a private investigator for a non-individual.
I'll hear from Ms. Mindy in just one moment. But one other thing, though. Is the state ready to go to trial just against Mr. Handte in 2 weeks?
Well, I will say yes. For the record, yes, but obviously is not preferable. That would sort of result in, I think the thing maybe Mr. Hillius wanted a de facto severance of the defendants. That is hugely inefficient in terms of judicial economy. Hugely inefficient. We know that he is in custody on this court's warrant, and extradition proceedings have begun. So,
But of course, there are many more layers there. Because if he's extradited, unless there's a legal basis why he should not be, but if he is, he's brought back to the Washoe County Jail. Then he has to be evaluated by two professionals, consistent with the statute and consistent with the court's prior order, to determine if he's competent to proceed to adjudication. Let's play this out. If one says yes and one says no, then I usually appoint a sort of tiebreaker. Then, depending on what that person opines, the court can accept, parties can accept, or traverse, in which case there's a hearing and then counsel gets appointed for Mr. Hilligus. In fact, counsel will likely be appointed for Mr. Hilligus once he's returned to Nevada for purposes of to contest any order the court has made with respect to the competency. So we are possibly months and months away from having Mr. Hillegas, and if he's found not competent, then directed to Lakes Crossing, hopefully to be treated to competency, and then another hearing depending on what, it could be a while.
It could be a while, and, Your Honor, I did have occasion to speak to Mr. Handte before court on this particular issue. We are not in agreement on the counsel issue, or I don't think many other issues, but on this issue, I think we are on the same page. The court may recall that even as recently as the last trial setting, Handte, through counsel, was desirous of a joint trial. The ability to, a desire to go to trial with Mr. Hillegas. Mr. Handte has shared, I won't sort of share what we talked about, but just in general sense, still desirous of that, a joint trial with Mr. Hillegas. Now, on this question of competency, of course, we know that can play out rather in a lengthy fashion. However, I would suggest that when, the court says if he comes back, I would say when he comes back, I would urge this court to take a fresh look at because competency, of course, is a current, right, is a current assessment. Are you currently able to aid and assistant counsel and understand the nature of the proceedings? Because that can be fluid, I would urge this court to take a look at that anew when we have Mr. Hillegas back, because there's a school of thought that although in the sort of vernacular sense, Mr. Hillegas has sort of delusional beliefs, sort of these fundamentalist, bizarre, sovereign citizen beliefs. I think within psychology, psychiatry, they would not be termed as delusional. They would more be, and it is an ongoing issue within psychology, which this question of sort of conspiratorial thinking that is widely held. So I think there would be room there for challenge, either a fresh look or challenges from either side on the question of whether he is then currently competent to proceed. Of course, the question of whether he gets counsel, interesting because he also has insisted on representing himself, and I suspect he will continue to do so. So sort of stepping back a little bit, I think this question of continuing the trial, I know the case has been going a very long time, but doing a pro per trial or with 2 pro per defendants, I think that's a thing this court for judicial economy.
Let's start, I think you may have a seat and we'll talk some more. So Mr. Handte, you can address the court seated if you'd like, or standing, whatever you're more comfortable. Okay. So let's talk about the issue of this recently filed motion for assistance of legal counsel and administrative functions. Do you remember when you and I talked, when you asked to represent yourself a couple times, and at least once we indicated that the state was going to have more legal experience at trying cases, preparing cases,
Remember,
all that stuff, and that you might be, I don't know if I use this analogy, but out in front of your skis a little bit here. But you said, Judge, I'm ready to do it. I'm confident to go forward. So what's changed?
well, what's changed, Judge, is the fact that I've, like you stated just a few minutes ago, on the record, that I put a lot of time and effort into these motions that have been denied by the court. And in that aspect right there, it shows me that maybe I am a little bit over my skis, not so much way over, but a little bit over my skis. And that's why I'm requesting legal assistance. It's entitled to me under the 6th Amendment of the United States Constitution, as well as the Nevada Constitution. I believe I should take full advantage of that. As for the investigation process, there are other key pieces of the puzzle that I've uncovered in my own findings that need to be addressed, and that has to be done through an investigatory process.
Well, let me stop you there. I mean, this case has been pending for a long
I
time.
understand.
Because one side might say, or the judge might say, okay, good point, but you've had months and months and months to do it, and why all of a sudden with 2 weeks to go, are we asking for more time?
Because, Judge, I've had months and months of lawyers that I've retained not doing their job. not listening to me. Again, I didn't dig ditches for 30 years. I was a law enforcement officer. I was in court thousands of times. I saw a lot of testimony. I saw a lot of good rulings. I saw some bad rulings. I saw some good attorneys. I saw some bad attorneys. So I juggle that all as my thought process here. And when I have attorneys that I state and pay to do something and they don't do it, where's that work ethics class that says you keep paying that person not to do a job? And that's why I got to the conclusion why I got rid of Mr. Pitaro. Mr. Gilbert was kind of a non-entity almost from the beginning. And then Mr. Kozak. And in less than 30 days, all of a sudden I got presented a bill for $5,000, which, again, I am limited financial resources. So I took everything into consideration when I met with Mr. Kozak last. I said, if this is going to go way out of control, because Mr. Pitaro was previously paid by my former employer, I'm not going to even afford you. And so everything factors in, Judge. It's fair to me and to the court and even to the prosecution that we have everything dialed in to the best it can be. And I'm based on my experience in the courtroom and as a law enforcement professional. And I just don't think at this point in time with me going into this situation that I'm being fairly represented by just doing this on my own. And just to add into the record, Judge, I told this to Mr. Stege as well. Prior to me retaining Mr. Kozak, and after I got rid of Mr. Kozak, I've contacted numerous attorneys, both here in Nevada and in another state that's licensed to practice in Nevada. And it's like a wall that's set up. I can't get some of them even call me back in a free consultation. So something tells me there that they're either afraid to do it, or don't want to do it, or being told not to do it. I don't want to go into the conspiratorial end here, but at least one, they're not even getting back to me. So I'm kind of caught between a rock and a hard place, so to speak. I'm trying to do the best I can with the resources I have. And I don't foresee, unless somebody wants to walk through the door and say, I'll take the case pro bono, I don't foresee myself retaining a fourth attorney. I just need assistance with the defense of my case.
Well, let's be clear on something. If the court grants your request, here's what happens. And I'm not granting it yet. I'm just thinking out loud procedurally what happens. If I grant the request, we use 2 weeks from today, which would have been the first day of trial, for a status hearing. So I appoint today the Washoe County Public Defender's Office. They get my order, and they then, whoever's in charge there of assigning cases, assigns it to one of their deputy public defenders. He or she then reaches out to you and you meet. Not to explain the whole universe of the case, but to at least get the lay of the land. That attorney then comes in, we use the date and time of the 14th, Monday morning at 9, to see how much time that attorney needs to get up to speed. We also, at that time, would set for hearing a couple of these motions that are now pending. Change venue, motion for writ of mandamus,
Former paupers.
and former paupers, although that probably goes by the wayside if you get an attorney at public expense. And we pick a new trial date, and then we reverse engineer some of the pre-trial deadlines. But it would be with the clear directive from the court that don't expect, if friction arises between client and attorney, to immediately have the right to have a different attorney appointed. Clients may not like what they hear. Clients may ask the attorney to do something, file something, approach it a certain way. Clients' input, of course, expected, valued, considered, but the attorney often controls the course of the defense. And friction caused by a client who believes the case should be pursued or approached or researched or witnesses presented or legal briefs filed differently, that does not create a conflict sufficient under Young versus State of Nevada for a new attorney to be appointed. In other words, this would be the one shot, absent
And I understand that,
good cause.
the only friction that really was created between any attorney and I was with Mr. Vitaro. Mr. Kozak, basically, I just couldn't get to the point of being able to financially afford him. And see, Mr. Vitaro had already been compensated. So the only friction that I saw was between Mr. Vitaro and myself.
Okay.
As for a public defender, that would be acceptable to me as long as he would.
He or she.
He or she would do consideration, understanding, and see where I'm coming from, which previous attorneys.
Well, that's part of their job description, that and a lot more. But I'm just telling you that occasionally, people that are represented by the public defender come in and say, Judge, we're in an impasse. I can't work with this person. They won't do what I direct them to do. That's not the test. The test is that if there is I'm not going to state what the law is on it, because I'm not anticipating us to be in that position if the court postpones this trial, moves it out to 2023, and appoints a new attorney. But I'm just thinking if that's the right thing to do, taking into account the procedural status of this case, the fact that twice we've had a question and answer under oath where I explained to you the consequences of representing yourself, and here at the close to the 11th hour, you've now made apparently a realization that you would be best served by having the assistance of legal counsel. And you're also telling the court that you cannot afford one unless one's appointed for you, right?
Correct, and also, and I also mentioned this to Mr. Stege that now that Mr. Hilligus is in custody, I intend to call him as a witness.
So if the case is pending against him, he certainly can invoke his Fifth Amendment right against self-incrimination. So,
Is the court interested in briefing on this subject? This representation?
well, sure, but I mean, let's back up. A week from today, I'm picking a jury on another criminal justice case. My time this week is spent on other matters, including preparing for that trial. Next week, I'm off the grid because I'm in trial, and then, of course, Friday is Veterans Day. So I don't know when we would hear it. I was going to suggest if there are any motions or any issues that we need to take up for this trial, if we were to start in 2 weeks, we would take them up this Friday morning, but so I don't know how much bandwidth anyone has between now and the end of this week. I mean, what's overlaying all this is Mr. Hilligus has now been picked up on the warrant.
Right.
If he were not on the warrant, well, probably a little bit different scenario. The fact that he's in custody now and the issues raised by Mr. Handte.
And, right. Friday, no, I won't be here. But I think I would just urge the court clarity here. Is this a standby counsel situation? Is this public lawyer, public defender, a finding of indigence, which I think
Well, I would have to put him under oath in a minute,
we're
but
kind of far away from that based, I mean, typically the DA doesn't weigh in on that, but given the history in this case, I might be inclined to weigh in on whether Handte is indigent. Or pro se is no longer at the table and he will be represented by a lawyer. That's just clarity for those purposes, especially given the history of sort of waffling my word in terms of who's going to represent. And as to
yeah, waffling that's a strong word. I would say a change of approach,
Yes.
change of view. And the court has tried to clarify that if there's an appointment made here, the court's expecting this to be the attorney that Mr. Handte fights with going forward from now until the end of the case. Give me just a moment here to give this a little bit further thought. right, Mr. Handte, I'm going to put you under oath and ask you some questions about your finances. So you'll be answering under penalty of perjury. Would you please raise your right hand and be sworn? Mr. Gainer?
Solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
Thank you. So, Mr. Handte, you're working full-time right now, is that correct?
Correct.
And taking into account what your net pay is after taxes, and then subtracting from that your living expenses, rent or mortgage, food, medical care, clothing, dental care, gasoline, insurance, all the things that go into modern life. Is there anything left over? And if so, about how much monthly?
Well, first and foremost, since this gas crisis has taken place, I've had to purchase another more economical vehicle. It's not a big purchase, but that's an outlay that factored into it. So at the end of after I pay all my bills and stuff, I have about $2 left available, and that varies from paycheck to paycheck.
Okay, do you have a car payment now on this new vehicle you bought?
It's not new, it's a 2001 and
A new used vehicle?
new used vehicle.
Okay, do you have a car payment on that, or were you able to pick that?
I pay that to my landlord. I pay him, I've already post-dated checks to him for the payment of the car.
You bought it from him?
Yes.
Do you have a net worth of assets? If you took everything you own, all your stuff, and put a financial value on it, is it more or less than $10,000 at this time?
Well, Judge, I don't really have anything left. It's less than $10,000. The only things I have left is in the storage unit. After my wife left, took both vehicles and pretty much every piece of furniture in the house, I don't have anything left.
You get a pension though from the state of Nevada, and what is that per month?
Approximately $2,000, but that all factors into the mortgage, the rent, the gasoline, the groceries, the utilities.
I got it. So when you said you have about $250 to $350 a month left over, you were factoring in
Pay and pension.
pay and pension, right? Do you have income from any other source?
No, sir.
Do you have any outstanding civil judgments against you?
I have a pending civil case that is in limbo right now, but no, that's the only thing I can think of.
Okay, one of the cases, the state wanted the court to indicate that it could bring up at trial to show your familiarity with courts and legal papers was, I think, Wells Fargo case. Mr.
Yeah.
Stege, is that a case that was on the list?
Where the bank illegally took $63,000.
All right, and so is there anything, is there still a judgment? Let me just, one at a time. Does Wells Fargo continue to have a judgment against you?
No, I had to forfeit the money to the people who filed the suit against me. That's all I wanted was the money.
That,
So I lost that money.
all right, but no civil judgments against you as far as you know?
No.
Mr. Stege?
I wonder if the court might inquire a bit deeper, like, I'm struck that most people in the world have very little left over at the end of their.
Well, I asked him if his
paycheck.
net worth is less or more than $10,000, and he said it's less. Did I hear you correctly?
Correct.
So if you sold everything you have right now, and you monetized, turned it into money, would it be less than $10,000?
$10,000, correct.
Is your, are you currently in divorce proceedings?
Well, I have to refile the divorce. I owe that attorney some money as well, but I kind of stayed that off while this case is pending.
So it's on hold?
It's on hold. Like I said, I owe him some more money, but he's taking payments, small payments. So that was an agreement between he and I. But that's still up in the air, so to speak, the divorce itself.
Well, the court does not find that Mr. Handte is attempting to improperly manipulate the system. The court finds that his request is sincere and is a product of apparently further reflection on his part that he would benefit in defending himself from the assistance of legal counsel. While the court does recall explaining to Mr. Handte in one or more of our previous hearings including one or more of the Feretta hearings, that a decision to represent oneself is not to be made lightly, that if the defendant later changes his mind, the court has discretion, depending on the circumstances and timing. But notwithstanding that, and taking into account Mr. Handte's financial status, the motion for assistance of legal counsel and administrative functions, somewhat inartfully styled, but would like an attorney at public expense, is granted. Trial is vacated, so no trial. 9 o'clock though, November 14th, be back here for a status hearing. We're not going to hear argument on or make any decisions on pending motions at that time. What we're going to do is make sure that you have an attorney at that time. He or she comes in and we find out what their immediate calendar looks like. I'm hoping on that date and time, we can then set a new trial date. And 2 dates before the trial date, being a final pretrial conference and a motion to confirm trial. The attorney, I'll order a copy of the transcript of this hearing to be prepared and filed so that newly appointed counsel can read it and be aware of what the discussion was, including the issues that the court was prepared to address this morning. The court then does appoint the Washoe County Public Defender's Office to represent Mr. Handte in this case and all further proceedings. The motions that are now pending are continued to be determined after counsel appears and is prepared. The state can have from today 20 days to respond to the petition for writ of mandamus. Mr. Stege, on account of the upcoming holiday, if you need more time, try to work it out with newly appointed counsel. If not, please file a short motion. But again, the motions that are being postponed until we have a hearing after new counsel is appointed, prior bad acts, motion to strike evidence, motion to change venue. The informer pauperis is stayed because really that's probably not going to be an issue any longer. Any further request to change Mr. Handte's pretrial service status can be made at a later time. I'm not today changing his status. Issue whether the trial can be videoed is postponed until we get closer to the trial. Mr. Stege, anything else at this time?
No, well, no, I
Sort of?
sort of, yes, I'm
Okay.
sorry. The question of indigency, I do want to lay a record of, from the state's perspective, the defendant had Mr. Pitaro, who is probably a six-figure defender, very highly respected and accomplished lawyer, Mr. Gilbert as well, and Mr. Kozak. So this question of indigency ought not, in the state's view, and speaking specifically and broadly, the public defender is for indigent defendants, and the objection being that it's not sort of a counsel of convenience, right? Counsel because it is unknown what to do with Mr. Handte, rather than the question of he makes a salary. It's presumably not below the poverty threshold. He's not in custody. He gets a pension, things of that nature. He has a car, sold one car to another car, or has multiple cars.
Making payments to his landlord.
Making payments to his landlord. I mean, everyone has payments. The question of whether your paycheck is pretty much spent by the time the next payday comes around. That's, I think, a common feature of American life, rather than sort of as a matter of convenience. And of course, I don't really have a lot of dog in this fight, but just broadly speaking, this question of indigency, I think maybe I ought to have more scrutiny.
Well, I'll tell you this, and thank you. I'll tell you in response to what you just said. I have appointed attorneys of public expense on a showing, an under oath showing of financial wherewithal even greater than what Mr. Handte has just identified, but not much greater and not very often. So this is probably the exception, not the rule. There's no message to be delivered here on an ongoing basis that if somebody is able to pay their bills, but the court it's not lost on the court that this criminal justice process and the civil justice process and the family justice process has taken a financial toll on Mr. Handte. He's sworn under oath that the value of all his possessions, if liquidated, would be under $10,000. That he has between $250 and $350 a month left over, and he's pending a divorce proceeding which he's not currently able to afford or manage. So that's why. But yeah, your concerns are not lost on the court. So Mr. Handte, what you need to do, please, is stand by, come back to court in 2 weeks, make sure that your contact information is available to the state so that when new counsel is appointed, they can reach out to Mr. Stege if they need how to reach you. Meet with them. And I'll see you here Monday at 9 o'clock and actually, let's do this. How about 10 o'clock? That way, if you were meeting with the new attorney Monday morning for the first time, Mr. Handte, you can meet with them at 9, and then we could be here at 10. Mr. Stege, will 10 a.m. work for the state?
You're, on the 14th?
Yes.
Yes, thank you.
And Mr. Handte, 10 o'clock then. Okay. In contact with Mr. Hilligus pending further order of the court, directly or indirectly. Directly means you try to reach him, indirectly is you ask someone to reach him on your behalf. Your current pretrial supervision remains as stated, although I've indicated previously I would possibly reconsider it depending on what was the showing to the court. Transcript's going to be filed promptly. I will sign an order later today directing the Washington County Public Defender's Office to begin representation. These motions are held in advance.
Do you want a court file stamp copy of this court?
I don't need that, sir. I'll get a copy once they release it from the queue and it's filed. It'll come right to me on my binder. That's all. Thank you very much, everyone.
Just clarifying, this is not standby counsel, this is fully
Not
represented.
standby counsel.
Thank you.
You're welcome. All right. Thank you, everyone. I wish you a nice afternoon. Court's in recess.
All rise.